Hey there, and welcome to this explainer. Today, we're diving into a fascinating and honestly highly relevant shift in the modern workplace. We're going to examine the surprising, almost borderless nature of modern Australian employment law. In an era where remote work is just the absolute norm, the legal boundaries of where a job actually exists are being completely rewritten. And let me tell you, the implications here are absolutely massive for both employers and employees all around the globe. Now, I want you to consider this question for a moment. Can you claim unfair dismissal in Australia if you have literally never set foot in the country? I mean, it sounds like an impossible legal paradox, right? Common sense would probably tell you that if you live and work overseas, you're subject to that local country's laws. But as we're about to see, digital communication has created this wild reality where your physical location might not matter nearly as much as the final destination of your emails. Okay, let's dive into this. Section 1, the overseas worker paradox. Let's meet our two completely remote protagonists. On one hand, we have David Sanderson, who lived and worked entirely in New Zealand, and Gautam Parimu, a U.S. citizen working all the way over in Argentina. Now, contrast that with their employers, Brightest Australia, based in Melbourne, and Lake Resources, headquartered in Sydney. We're talking about thousands of miles separating where these employees woke up to do their jobs every single day from where their bosses were actually sitting. Moving on to Section 2, fired by text message. To truly wrap our heads around how the law handles this massive geographic divide, let's walk through the timeline of David Sanderson's employment. In September 2024, he was hired by Brightest Australia to sell a subscription service called Flexi Plans to folks in New Zealand. Well, over the next several months, things apparently got pretty strained. In July 2025, his boss sent him 2 emails with the subject line, performance warning. And then on December 8th, 2025, things escalated incredibly fast. Sanderson was abruptly dismissed via a simple text message, which was then followed up by an email confirming his termination. Now, any workplace dispute has 2 sides, and it's important we look at both. The employer's stance was that Sanderson was required to generate 75 FlexiPlan sales, but he only managed to hit 32. To them, that was a clear failure, but Sanderson had a starkly different perspective. He explicitly told his boss, and I quote, "We can't produce wine from water." He argued that missing his targets wasn't a performance issue at all, but simply the result of being given incredibly low-quality marketing leads. So this fundamental disagreement led Sanderson to file an unfair dismissal claim with the Fair Work Commission. Here is how those competing claims stacked up. Brightest Australia filed an objection right out of the gate, basically saying, look, Sanderson lived and worked entirely in New Zealand, he did no meaningful work in Australia, so he has no right to claim under Australian law. They also maintained he was properly warned about his low sales. Sanderson, on the other hand, pointed out that those supposed warning emails never actually mentioned he was at risk of being fired. He was given no formal meeting, no real chance to respond, and therefore being fired by text message was procedurally unfair. So the crucial point is the actual legal definition of an Australian-based employee under Section 35 of the Fair Work Act 2009. This entire case hung on this exact piece of legal jargon. The Act says that if you're employed by an Australian employer, you're covered, unless you fall into a very specific exclusion. That exclusion removes employees who were both engaged outside Australia and who performed their duties outside Australia. Now, Sanderson obviously performed his duties outside Australia, but was he officially engaged outside Australia? Let's find out in Section 3, the email contract loophole. Now, what's really interesting about this slide is how it breaks down the exact legal mechanism, what you might call a Trojan horse technique, that gives Sanderson his victory. The Electronic Transactions Act actually bypasses physical geography altogether. Here's how it worked. Step 1, Sanderson signed his contract in New Zealand. Step 2, he emailed it back. Step 3, that email landed in an inbox in Victoria, Australia. Under the law, a contract formed by email is legally made in the place where the acceptance is received. So, because that email hit an Australian server, the Commission ruled he was legally engaged in Victoria. The loophole was completely shut. Because jurisdiction was firmly established, the Fair Work Commission went ahead and reviewed the actual dismissal itself, and they ruled in Sanderson's favor. They determined that the employer didn't follow the Small Business Fair Dismissal Code. Those warning emails, they were viewed as just exhortations to improve, not actual formal dismissal warnings. Because he was fired via text message with no formal meeting or chance to defend himself, the dismissal was deemed harsh, unjust, and unreasonable. Sanderson won and was awarded 2 weeks gross pay. It is a really stunning reminder of just how powerful digital paperwork can be. Let's move to and see how this builds in Section 4, the Global Executive Dispute. If you thought New Zealand to Melbourne was a bit of a stretch, get a load of this even more extreme geographic paradox. The employee here is Gautam Parimu, who is a United States citizen. He was hired as a chief operating officer to work on a massive lithium mine physically located in Argentina. The employer? Lake Resources NL, headquartered in Sydney, Australia. Parimu interviewed entirely over video, performed all his daily duties in South America, and had literally never traveled to Australia. Let's trace the timeline leading up to this dispute. In October 2021, the hiring process wrapped up with a Sydney-based director emailing Parimu an executive services agreement. On October 23rd, Parimu signed it and emailed it right back. The very next day, the director countersigned it. Fast forward a bit to January 9, 2023, and Parimu is dismissed effective immediately. In response, Parimu lodged a massive general protections claim under Part 3.1 of the Fair Work Act. Much like the Sanderson case, the employer immediately tried to block the claim on jurisdictional grounds. Lake Resources argued that engaged outside Australia referred strictly to Parimu's physical location when he signed the paperwork, which was obviously overseas. Parimu's defense, leaning heavily on earlier legal precedents, was that the word engaged refers to contract formation. And since his email acceptance hit a Sydney inbox, he was engaged right there in Australia. Amazingly, the Fair Work Commission ruled exactly as they did before. The electronic location of the contract formation completely bypassed the physical location of the worker. The contract was formed in Sydney, and Parimu's claim was given the green light to proceed. Which brings us nicely to Section 5, seeking workplace justice. So we've waded through some pretty heavy legal precedents here. But what does all this actually mean for everyday workers out there trying to navigate a dispute? Facing the Fair Work Commission against a corporate legal team is basically a classic David versus Goliath scenario. Enter the Australian Workplace Discrimination Representatives, or AWDR. They are specialist, non-lawyer advocates who help employees fight these exact types of battles. They cover everything from unfair dismissal and general protections to cases involving sexual harassment, toxic workplaces, and non-genuine redundancy. Now, that number 30 is absolutely crucial. ADDR has 30 years of experience, proudly standing shoulder to shoulder with everyday workers. They're serious specialists in mediation, negotiation, and arbitration. When an employee suddenly finds themselves locked out of their digital workspace or fired over a text message, having an experienced advocate to chart out a clear strategy is just vitally important. And here's another massive metric for you: 16,000. That is the incredible track record AWDR has built up, supporting over 16,000 clients across Australia. And as we've learned today, sometimes those clients are sitting in their living rooms in New Zealand or working on projects in South America. To me, that number highlights just how incredibly common these complex workplace disputes truly are. And this brilliantly illustrates how accessible AWDR makes workplace justice. Because strict time limits apply to fair work claims, acting fast is non-negotiable. AWDR operates a 24/7 support line, and yes, it's actually answered by real humans right in Australia at 1800-333-666. They offer free, confidential initial consultations, and for many cases, they work on a no-win, no-fee basis. This kind of setup ensures that everyday workers can actually afford to stand up for their rights without facing immediate financial ruin. Well, we've definitely covered a lot of ground today, haven't we? From abrupt text message firings to global executive showdowns. So I want to leave you with a final provocative thought to take away from this explainer. Take a good look at your own digital paperwork. If you work remotely, where did your signed contract actually land? Because as we've seen today, that simple act of hitting the send button might just legally anchor you to an Australian inbox, giving you a whole host of rights and protections you never even knew you had. Thanks so much for joining me to explore this fascinating topic.